Imagine this. Is a road roller just a vehicle or can it be considered a plant? Does printing books and conducting examinations come under the definition of an educational institution? Should tax laws carry penal provisions to create a deterrent effect? And if a government portal does not allow you to fix a mistake, is the fault in the technology or in the law itself? These questions are just not technical. Their answers decide whether a person saves on taxes and even safeguards their liberty, or whether the state secures the revenue it needs for welfare. Hello friends, Pranam. In this episode, I sit down with Mr. D.V. Pathy. He's a senior advocate at the Patna High Court. We talked about his remarkable journey as a lawyer in the specialized field of tax law, and through his experiences, we explored how taxation has evolved, how it is practiced in different forums in Bihar, and how landmark disputes have shaped the law itself. I hope you find this conversation as enlightening and engaging as I did. Welcome to this podcast, sir.
Yes, welcome.
So I would like to start from how, because of you, my two preconceived notions were dispelled. One of them were that it is always believed that a lawyer representing wealthy corporate clients come from privilege and money. And the other one being that Bihar does not have wealthy corporate clients. I thought that these were my personal assumptions, but that is not so true because these questions were posed to you in the Chief's Court. So perhaps we could start with you responding how you responded in the court earlier.
I would tell you one thing, and that must be understood by all new beginners who wish to choose law as their profession. I can tell you that this is a noble profession.
Right.
This doesn't invite only wealthy people. This invites people from all spheres of life, poor, downtrodden, wealthy or not wealthy. What is the measure is your hard work.
True.
How much hard work you have put in to make yourself suitable for the profession, and that is the whole story. As you said, that Bihar doesn't have a corporate client. See, many corporates are working in Bihar. If Bihar is not an industrial state, it is of course a state consuming state. Because that is why the major corporates in the country are selling their goods in Bihar. They are operating in Bihar one way or the other. And the moment they do some business in Bihar, be it trade or commerce or anything, then they are subject to tax legislation. And more in particular, the VAT, the sales tax of the state. Because the state is competent to impose sales tax on the commodity of sale or purchase under the relevant tax law.
Right.
Earlier we called it a Sales Tax Act, then later came the VAT Act. Now it is the GST era. But in all the legislations, what is taxable is a transaction of sale.
Right.
So those corporates are present here.
True.
And the moment they are present, there is bound to be some litigation one way or the other.
Right.
Then in that case, they will need help of a lawyer.
True.
And you have to be eligible for being selection to represent them.
True.
And the moment you are capable, you are bound to be selected. They won't select you from a particular ring. They will go by your merit. They would see your performance in the court. That is how I came. Started slowly, gradually, set my goals. And now you can see, I had the occasion of representing many corporate clients in the state of Bihar in the Patna High Court.
True. It is important that we record our journey, because it is always assumed that since you represent these wealthy clients, you must also come from money. And I saw this in the court when you were posed this question. So I believe it is important to record your journey, where you come from and how you have made it through. So,
see, I have a very humble beginning. I am born in an area called Lohanipur, near Kadamkuan area in Patna. and I studied, rather all my brothers studied in a school called Sir G.D. Patliputra High School. It was a Hindi medium school, like a government school, but of course a good school. We studied there, and after passing out, I had an aspiration firstly to become a doctor. So I did up to class 11th. Then at that time, it was class 11th. Matriculation, as they called it. But then for some reason, because the marks fell short of 1, I couldn't get through. Then later, my father suggested that I go in the commerce stream. And that would have come spontaneously, as I can tell you. And I got admitted in commerce. Became a good student in commerce.
So until class 11th, you studied in a Hindi medium?
Hindi medium school with physics, chemistry and biology. And then in a commerce stream with ICOM and BCom. But then with hard work, I could pick up accountancy, bookkeeping and everything, auditing. And I can tell you, I'm a distinction holder in all these 3 subjects of advanced accounting, in both my intermediate and my graduation.
So knowledge of finance, economics, accountancy, does that help for a lawyer who is practicing at the tax side?
I think so. Because taxation stems out from the commerce only. It is trade and business.
Right.
So you must understand the nuances and the intricacies of the accounting. The moment you understand accounting, then you know the debit and credit of it, what is coming in and what is going out, what is an asset, what is a liability. And then in that case, you measure it. Because under the if it is a concept of tax on income, it is the Income Tax Act. If it is a transaction of sale, then it is a VAT Act or a sales tax law that would be there. So you must know accounting
to identify the transaction,
to understand it.
Okay, great. So how did the option of studying law come into the picture?
See, after my BCom, my friend's father, Sri Keshav Prasad Kayaji, I fondly remember him today, and definitely
your
very
father
recently.
Is also court employee. He worked in a court.
No, my father was not in the court. My father was a stenographer in Burma Shell, the later version of when it was Indianized, taken over by the government of India. It became Bharat Petroleum Corporation Limited. But my father was a very voracious reader, and I can tell you, I learned the language and the art of reading the language, literature in which we are conversing from him only. He made me read so many novels, of course loud, with a dictionary in hand. And that is how I picked up the language.
Not from school?
Not from school, because I studied in a Hindi medium school. Yes.
Okay. So how much do you think language play a role in the practice of law? Do you think that if you couldn't have learned speaking in English, it would have become an impediment in your career?
See, I can tell you one thing. Being articulate about the profession, in conversation, in convincing what is what. Convincing is nothing but conveying, the art of conveying in the court. Not only writing, in my view. So the moment you communicate, the better you communicate, the better, with the better skills, then in that case, it shows more impression. In earlier days, you'll find that the lawyers used impeccable English. These days, you will not find. It is what is required today is a technical know-how, understanding of the subject, because things are too technical now. So one has, apart from the language, must also know the subject in the greater perspective.
So you are saying that language do not play such larger role, but the technicalities of the subject.
Technicalities, of course, will take over. Because with language, you cannot win a tax case.
Just with language alone.
Just with language, you cannot.
But do you think that creates an impression, one who could speak well in English?
See,
creates a good impression.
person who creates a good atmosphere in the court, what we call it a court craft, is not only by language, but definitely language has a big role to play. The better the communication skill, the better results you are likely to get, because the judge also feels impressed.
True. So you were talking about your friend, your father's friend, who made you think about career in law.
See, he was the one who suggested that I should join a senior's chamber who will practice tax. He knew that I did fairly well in college. I was good in writing also and in public also. So he commended that I join a senior's chamber with an extensive tax practice. So I learnt under him. He was late Mr. Khetan, S.N. Khetan. I worked with him for 6 long years as a chamber junior.
He practiced at the tax side.
Yes, he was at the helm of this affair in the tax litigation. Of course, he practiced only in the up to the tribunal stage.
Not at the High Court.
Not in the High Court.
Okay, so you started, you worked there for 6 years.
Yes.
And so basically, your area in which you are practicing today, that was not it wasn't an organic decision that you had to practice in a taxation side, but it came out to you naturally. And since you had a background in accountancy and finance, that really helped.
Yes, that helped.
Until this point of time, have you not thought of any other career avenues? Have you thought of, or were you clear that you have to practice law?
In the beginning of the time, in the beginning of my career rather, I was not very conscious of how to become a lawyer. I didn't know it. But then I kept on working. And after 6 years, when I left my senior's chamber, I would have got one file. And with one file, I worked hard, and that gradually added up few more files. And that were mostly related to filing of income tax returns. And then came gradually an opportunity to file a first appeal. And thereafter, I appeared in the first appeal. After that, for some more time, a second appeal came. That was before the tribunal. And when I was arguing one matter in the tribunal, one of a senior counsel, whom I affectionately called Bhaiya, means big brother, he exhorted upon me and rather suggested that, Pathy, why don't you come to the High Court? And it was he who made me argue the first case before the High Court.
What
I do fondly remember, he is Sri Pavan Kumar Rajgaria. He is also no more. He died very young. But then I remember him every time. I think once a day, definitely yes.
He brought you.
He showed me the way to the High Court.
And since then,
I am there in the High Court. Yes. And it is now, I think, 38, 39 years of my professional journey in the High Court. And now I have appeared in several High Courts across the country, including the Supreme Court.
Right. Yes. So what I was trying to understand is, so when you are starting your career, when you are young, you have a lot of options. You could do so many things.
Yes.
So how does one make up one's mind that, okay, you have to do this, you stick here, and if you stick for long, you will do well. So because there's a plethora of options, and plethora of options, what does it do? It confuses you at times that you could do this, you could do that. So have you had such struggles with you, or at what point of time you were so clear that, okay, now it's working and this is all that I'm going to do throughout my life?
See, in a juvenile mind, there are a lot of thoughts.
Right.
When you pass your graduations, you have so many options of becoming a probationary officer or being an officer in the administrative service or the judicial service. But then, having taken up my job as a lawyer and particularly worked as a counsel for 6 long years in a senior's chamber, I thought that when the opportunities kept coming, I did not think of anything else. I did not think. I pursued only one direction, and that was practicing law and law alone. And I can tell you that I practiced only tax law. Definitely direct and indirect tax, both.
I've only seen you in the court arguing tax matters. You on the petitioner side and Ms. Archana Sinha representing income tax.
Yes, I have been always on the petitioner side.
On the petitioner.
Now I have many briefs from the state corporations also, but I appear even then, even in those cases where they are also petitioners. I have never represented a government.
So, what are the different forums which are here in Bihar on the tax side? GST tribunal is still not constituted. No?
GST tribunal is not constituted, but of late the government has been starting appointing members of the tribunal. So I think it is going to take time because the courts are to be set up, the councils are to be appointed on the state side, on the central side, and then petitioners' councils are definitely available. The moment the tribunal will start working, then I think the filing would begin and the matters would be fixed and the lawyers would be arguing on both sides. But the infrastructure is yet to be created.
So GST has been introduced, but the cases which were earlier there under the Sales Act, under VAT Act, those cases are still handled by the respective tribunal under those acts?
See, old cases under the VAT Act are taken up by the Commercial Taxes Tribunal. That's its office near Gandhi Maidan, the courtroom, where the old matters are there. Of course, there's a lot of backlogs even in the tribunal. So VAT is still alive that way. And then matters which are lost in the tribunal, then they will find their way to the High Court. And then there the pendency of the VAT cases are also there.
So you are primarily representing at the High Court level. You don't go to the tribunal.
I go to the tribunal. I appear in the Income Tax Appellate Tribunal. I appear in the Commercial Tax Tribunal. I appear in the Central Excise and Service Tax Appellate Tribunal, which has its bench at Kolkata.
Kolkata, on the company law side, the tribunal is again in Kolkata for Bihar.
Yes. I do not practice company law.
But I was generally asking.
Yes.
NCLT is in Kolkata. Yes. So, coming back to the High Court, so tax matters at the High Court have very limited, like the matters that I have seen you in the court. So, in all of those matters, the grounds on which those matters come before the High Court were very limited, in a way that either in those cases, principle of natural justice were not observed, or statutory appeal were there. So High Court has a very, I believe, a very limited scope when it comes to tax matters.
See, I can tell you, the litigations in tax matter before the High Court are primarily two. One is a writ jurisdiction and one is an appellate jurisdiction. I'll just explain you in a short while.
Please.
So far as writ jurisdiction is concerned, it is now a settled law. Whirlpool judgment of the Honorable Supreme Court is there. Now the latest judgment is of Godrej Sarali, where the Honorable Supreme Court has outlined the 4 circumstances in which the High Court would exercise writ jurisdiction under Article 226 of the Constitution of India.
Violation of fundamental rights.
These are the 4 violation of fundamental right, natural justice being violated, statutory provisions.
Statutory appeals?
Yes. No, statutory provisions being violated.
Okay.
And then it is a question of jurisdiction. So in 4 circumstances, the writ would lie, not otherwise. So therefore, there is a limited scope to the exercise of writ jurisdiction in the High Court. So therefore, once the writ petitions are filed before the High Court, one has to see as to whether these 4 preconditions outlined by the Honorable Supreme Court in earlier cases, including the Godrej Sarali, the latest judgment, are satisfied. Unless otherwise, the High Court will not exercise its extra prerogative writ jurisdiction. That is one. So far as the appellate remedy is concerned, against the order of a tax tribunal, be that under the Income Tax Act or be that under the Sales Tax Law. An appeal before the High Court is available, but there again on a substantial question of law. So firstly, one has to satisfy the court that a substantial question of law arises out of the order of the tribunal.
True.
If you do not satisfy this precondition, then perhaps the appeal would be dismissed at the threshold itself.
Okay, on the High Court level, I understood. What are the differences between the tribunal that are constituted under central law, say income tax, and a tribunal which is constituted under state law? So, in their workings, are there any difference? What differences do you
see? Primarily, the income tax tribunal or a central excise tribunal, they deal with the specific subject matters only. The members of the tribunal are from the same field, one from the departmental side, one who is a chief commissioner is an accountant member. And so far as the judicial side is concerned, they are to be represented by a judicial member who is either a district judge or a lawyer who is practicing, and the criteria are different. Criteria are fixed, I can tell you. So that is how a judicial member gets appointed to the tribunal.
Both
and they are specialists. They are specialists in the subject. Similarly, in the Central Excise Tribunal, the persons are appointed from the Central Excise Department. And of course, the advocates are there. The chartered accountants are also there.
Right.
And in the sales tax, one chairman is there who is a member of the what you call departmentally elected. Mostly they are retired members, either from the audit department or a sales tax department, and presided by the chairman who is a district judge.
So these criteria are same for the central tribunal as well as the tribunal that is constituted?
More or less same.
Is there, do you see any difference in the quality of judgments that comes out of?
I should not delve into the subject of the quality of a judge. He may be a member of a tribunal or he may be a member of a state tribunal. See, it is an area of expertise under the sales tax law or the central law. And the work of a lawyer is only to argue before the court and not to evaluate the court itself.
No, not in that way. I was asking in a way that generally people believe that someone, now I'm trying to understand from first principle, someone believes that one who has cleared UPSC is more qualified than someone who is clearing BPSC. So I was trying to understand from same parallel that central tribunal, is the workings any way better than the tribunal which is constituted under state?
I somehow do not agree with what you have said, that a BPSC person would be less qualified.
No, that is again assumptions without any evidence.
See,
that is how people
there is
believe.
Nothing like an evidence on that subject.
No, not at all.
But then one is an all India competition and one is a state competition.
Right.
So there is bound to be some difference in the participation level. But of course, I have seen persons, even in the state side, those who pass BPSC, they are extraordinarily brilliant.
True.
And they do compare with those selection on an all India side.
Not to doubt that, but generally since the competition is more on the central level than what is there.
Naturally,
the responsibilities are more on the central level than on the state level. So I was trying to make a parallel comparison. So central tribunal, is it any better than the state tribunal because the responsibilities are more, the stakes are higher that way?
See, in earlier times, I would find that the members of the central tax tribunals, be it income tax or a central excise tribunal, they were well versed, and I would say that they will suggest lawyers to ways and means of succeeding in a matter. They would give points. That would happen even in the high courts. That the lawyer at the bench arguing was suggested some point by the judge sitting on the bench. And even the honorable judge would point out that, counsel, did you read that judgment? And perhaps I have experienced it. I have experienced it in person. When the Honorable Chief Justice himself said, Mr. Pathy, did you read this judgment? Or if you have not come, read it and come tomorrow. So those were the things which are not to be seen now, of course.
Like this faceless appeal, faceless assessment. I believe faceless appeal is there in the central tribunal, which is not there in the state.
In the state, we don't have a faceless legislation at all. There is a special provision in the income tax which permits dealing in first appeal through a faceless resign. We have a specific statutory provision in the Income Tax Act.
But that
similar that is there only in case of first appeals before the commissioner appeal.
Okay.
And in the state legislation, there is no such provision. So there is no faceless.
So basically, this is what I was trying to understand, that technology, introduction of technology is more on the central side than on the state side.
Exactly, more on that. And I can tell you one thing more about faceless. It can be with face also. The statute provides that in case you want to be heard in person, then you have to fill up a particular form on the website.
Okay, so it's an
while
option.
Filing an appeal. So you can have a video conferencing where you can see the authority, the appellate authority, who is hearing you out.
So both the options are available.
So both the options are there. Maybe you may not physically see him. You don't appear with him before him in person, but you appear through a video conference. He sees you and you see him, and that is how you can argue your case.
Okay. So that option is there for the first appeal on the central side, but it's not there on the state side.
It is not on the state side.
Okay.
Yes.
Okay, great. My next question would be, what are your views on the recent overhauling of new Income Tax Act? Our finance minister has said, I've heard her speech, that she's removing a lot of redundant provisions and making the language simpler. I believe from 800 odd sections are coming down to, I don't know, some 500 or something. So
it is always better.
It is always better.
It is always better that the law is made simple. But I'm afraid whether it would be as simple as being advertised.
Okay.
Because the tax by its very name suggests, if you read the dictionary meaning of tax, then it would be equated with taxing. And it is nothing than putting hardship on you. It is extortion. When you read the definition of tax, it is a necessary extraction or exaction, what they call it. So that is what they say. Yes.
But I have read several studies that says that simplification of language of law has a direct impact on a country's GDP. That if a language of law is simplified, that productively helps in people doing business and lowering down the various disputes and conflicts. So if a language is simplified, like for example, in tax matters, what I see is much more interpreted than other laws, where every single word has such implication, right? I could recall a case that you were also part of, Bihar state text matter or something, where the word educational institution has to be defined, and the entire case was dependent upon the court's judgment, where how this one expression is defined, and that expression itself decides the tax liability of the party or what the state would get. So simplification of language does help.
I'll just explain you. In income tax, there is nothing like naming a particular activity. It says charitable purpose. That is the definition. And what a charitable purpose is there, that is also to be found in section 215, which says education. Now, as you have given it, now today, yoga is also a part of charitable purpose. Even giving discourses is part of a charitable purpose, right? So, if you look at the word education, Then earlier it was confined to a classroom training, a classroom education as we understand it, like we went to school and the teacher was there and the taught was there. But today, with greater expansion, the word education has come to be defined in several ways. Like you said that the case of Bihar State Textbook Publishing Corporation, which I had the privilege to argue before the High Court on a substantial question of law. That was in an appeal against the order of the tribunal. So the issue that was being considered by the Honorable High Court was as to whether printing and publishing of textbook for a government curriculum was educational activity or not. The matter came to be decided by the Honorable High Court to say that it was incidental to the education. So therefore it was an educational activity, and I can tell you that so far as charitable purpose is concerned, they are all exempt, being charitable organization registered under 11 of the Income Tax Act. Then again another question arose before the High Court in case of Bihar Combined Board, where another vexed question was there as to whether conduct of examination for admission in a government-run college was educational activity or not. It was answered in the affirmative. So therefore, see, but then as you said, the simpler law means they would have to say that a school is exempt from tax, a printing press that prints school books is exempt from tax, or a person who conducts examination is exempt from tax. I don't think that the law can be couched in such a language. The activities would definitely be there. Let us see.
And activities, I also believe, changes with time, but law does not keep up with time, in a way that earlier so many government examinations weren't being conducted. So I believe this dispute that we were just talking about, where several centers, they conduct government examinations and they are seeking exemption under whether or not they would fall under educational institution. So law cannot be made very clear on those points.
See, it would all depend upon whether, because there are bound to be conditions the moment the government frees you from tax. That is what is called exemption. That you don't have a tax liability. What is the purpose? I can tell you what is the purpose of giving exemption. Is that you put more money in the purpose. Because the word work today is to spread education by whatever means. And if a charitable institution who is working on educational activity is given more money to invest in the activity, then perhaps the society would benefit a large. That is what is the intent of the legislation. It is not to exempt a coaching institute, that also exempt. That is a commercial activity, I would say. Yes.
Because in these two cases that you are part of, printing of books and conducting of examinations were held ancillary to education.
Yes.
But I have read cases like there was this one case, Sikshana Trust in, I believe it was in Karnataka, where
that was Sarv Sikshana Trust.
So they were
that's a lead matter in education by the
on
Supreme
education.
Court.
Yes. So in that case, they were arguing that news publishing of newspaper is also an education activity.
Yes.
But court did not agree with that view, because media, newspaper, all of these are not direct educational activities, is what.
See, as I explained to you, if there is a taint of commerciality in a transaction, then definitely it cannot be held to be a charitable activity. That is why even when a proviso is added to the definition of charitable purpose in section 2 subclause 15 of the Income Tax Act, they have limited the monetary inflow.
So this subclause were added pursuant to these cases or before?
No, they
was
were
there earlier.
incorporated also. There were additions. And there have been additions to spread the arena of charitable purpose also. Watersheds and wildlife and yoga, these have come with times.
So on the central side also, there are such disputes that I have seen where the entire dispute is based on the interpretation of an expression. And on the state side also, again, a case where I believe under the VAT Act, where a road roller was a road roller is a plant or a motor vehicle has to be decided
Yes.
that you are part of. Now again, a general public see that, okay, what is motor vehicle? Any vehicle that moves which has a motor in it. With that definition, road roller would be a motor vehicle, but court did not. Court said that it's a moving plant, and given a broader meaning to plant itself.
Fortunately, I had the privilege of arguing that matter before the Honorable High Court. What was being sought by the tax authority was to classify a road roller and road making equipments such as pavers, boulders, etc., mixer plants as a motor vehicle, for the reason they were put on the wheels and they were motorized. I can tell you why the dispute arose was only with regard to the rate of tax. So far as motor vehicle was concerned, it was 12.5%, and so far as plant was concerned, it was 4 to 5%. So naturally, there is a wide gap of 8% that makes a hell of a difference.
Yes.
So far as the commercial world is concerned. So the client, who was a manufacturer of road rollers, he had been contending all through in the lower courts that he was making up road equipment, and all these were road equipments only. And the derivations were from the Bengal Act. There you can find specific definition of road vehicles also under the head of plant. So a thought came from there.
Okay.
But then that argument was not acceded to by the Honorable High Court, which went on its own interpretation what a motor vehicle would be. And we relied on several judgments of the Supreme Court as to what plant would be. Like the scientific engineering case. I remember having started my arguments with AIR 22 Supreme Court, Privy Council. AIR 1922 Privy Council, where the Honorable Judge was considering whether a water tank on the rooftop was a plant or not. And from there, the law was enunciated. And the Honorable Supreme Court, that was considered by the Supreme Court in this Scientific Engineering Corporation case, and that was followed all along by the Honorable Supreme Court and various high courts in the country. The turn was in Patna High Court, that we relied on all these cases with a huge paper book filed before the Honorable High Court, saying that a long line of judicial precedent. But then I tell you, the judgment rendered by Her Lordships then, Honorable Justice Rekha Doshet, is a classic judgment by itself. You will feel that you will go into the arena of the Privy Council then, and there Her Lordships has gone on to explain what a vehicle would be, motor vehicle would be, and to say so plainly and lucidly that which is used to commute the passengers, and road rollers does not. So therefore, that was one great reason that had weighed with the High Court. I can tell you, with the state was aggrieved by the order, they filed a special leave petition before the Supreme Court. The Honorable Supreme Court, after hearing, agreed with the High Court and dismissed the SLP. So this was one of great contentious issues before the High Court. And I can tell you, you have rightly said that tax legislation is vexatious legislation, and that is only what you call an exaction that is taking place. We have to prevent that as a tax lawyer by putting forth certain good points before the High Court, that one has to look into the purpose.
True.
Yes.
And I believe such clarification can never come from department, and where there's such conflict where an expression has to be interpreted, it can only be interpreted by court, because both these parties are at two different ends.
I'll tell you very clearly. The authorities working under a tax legislation are creatures of a statute, and they cannot go beyond the statute. So therefore, they cannot interpret a law. And therefore, we seek refuge of the High Court in interpreting a law or the Honorable Supreme Court.
True.
Because creatures of a law by themselves cannot interpret a law or its intention.
True.
That is how we have a long line of decisions, you see, interpreting a subject matter. A small subject matter is dealt with in several pages to explain the meaning of one word, what would be. Yes.
That is not their discretion at all to interpret the law. They have to work under the bounds of law, what is clearly mentioned in the law.
See, they are working for collection of tax. And in my humble view, they cannot be expected to lean in favor of an assessee without any precedence. Unless there is a precedent on the subject, they are bound to make a different interpretation.
No, but in these cases which we have just discussed, there were precedents, but there were precedents which were set on the Privy Council side. So a person representing the department would not put so much work into pulling out such precedents which goes to so long, which is in the favor of the assessee.
By precedent, I meant that a similar law was there. A similar judgment was there on the subject. So assuming if there was a sub-judgment already that road roller was planned, then perhaps there would have been no dispute. Under Article 142, if that judgment of the Supreme Court was there or a jurisdictional High Court was there, then that was binding on the authority. But then those were judgments in different context. Those were judgments.
So road roller is a plant or not was not defined, but what is a plant itself was defined.
What a plant would constitute. Like I asked for example, I'll tell you. Plant was defined as a combination of machines. I'll put you with a very small example. You have a washing machine at home. There are components in it. You have air conditioners at home. There are components in it. Fan, bells, tubes, so many things are there. So it is a combination of machine.
Right.
But then they are specifically classified in a particular schedule of the state legislation. So bring it to tax at another rate. Whatever you have is a machine.
Right.
Even the podcast, this thing, what you call your microphone or a recorder or a TV, whatever you have is a combination of machine only.
Yeah.
So are they to be put in the same umbrella? No. Because it depends on the classification.
Right.
And classification is within the realm of the legislation. You can't question that. That is a legislative wisdom, we call it.
Right.
Yes.
That brings me to the question that how much discretion do tax officers really have? In a way, where I'm coming from is that, okay, they have to work under the bounds of law, what is clearly mentioned, but they do have discretion to do assessment, reassessment, classification that we were just discussing. They do have discretion to search, seizure, to various enforcement, penalties. So that is where their discretion comes into the picture. Now, where they are taking action under the bounds of law. But what about inaction?
I'll tell you one thing. The moment you say tax authority and their functions, if you go back to the Chanakya regime, then what was the slogan? What is the sloka for that? Koshamulo Danda. Means it is for the recovery. Money, exaction is for the welfare.
Right.
And if you don't, then you will be punished. The same thing has been adopted in a tax legislation. The function, see, we are a welfare state, and for the welfare of the people, how does the government get the money? They'll get money by compulsory exaction from a transaction, whether it be of income or a sale or a manufacture as it used to be.
Okay.
So the money has come to the coffers of the state exchequer, and which is to be eventually used for the welfare. Whether it is spent for the welfare or not is not the what you call the power of or the authority of the person paying the tax. It is absolutely within the realm of the government, the manner in which it spends. But in a welfare nation, as we understand it, there is a compulsory exaction for welfare. So if you don't follow, that is why tax evasion has been made a punishable offense by way of penalties when you try to evade taxes, of course linked with the quantum of tax payable, and then prosecution when there is a deliberateness involved in it. We have deliberately done it.
Right.
See, now things are very clear. Assuming a tax has escaped assessment and a penal provision is applicable, or maybe a prosecution provision is available. By prosecution, you understand that there is a prosecution provision in all the tax legislations. They can put you behind bars. So there you have to see as to whether, assuming I interpreted it in one manner and tried to save my tax, and that was not found favorable after a long line of arguments. It was a debatable issue. There the courts have held that tax planning resulting in evasion or less payment of tax, I would not call it evasion stricto sensu, less payment of tax. So non-payment of tax by itself, I can tell you, the courts have held in several judgments, is not a punishable offense.
That
for
goes
which
on
it
to
cannot
the
be
basic
visited
principle
with,
of criminal law. Mens rea should be there.
No, mens rea is well settled now. That mens rea is not applicable to a tax proceeding. You cannot say about a guilty mind. Earlier times, Anwar Ali's case, if you can recall, the Supreme Court considered the issue as to whether there was a deliberateness or not. But now when you look at the new Income Tax Act, there is a concept of underreporting and misreporting, and they go on to define what a underreporting will mean, and they define it as the difference between the returned income and an assessed income. I put a question to myself humbly as to whether that if the difference has resulted due to some difference of opinion, then whether in that case those provisions are applicable, because the law says he has not been able to explain to the satisfaction of the officer. That is the language employed in the statute. Right? So there he may not be satisfied. I have given my explanation. He is not satisfied. But then whether at all the penalty will be so automatic, I have doubts about it.
So what are your views when it comes to criminalization of tax disputes? That such penal provision should be part of, because in all the legislations that we have, be it on central side, on the state side, there are some penal provisions.
I can tell you, in my humble view, deterrence should not be attached to a tax legislation unless it is deliberate with a view to defraud the state. Deterrent punishments are called for only in defrauding case. Like our recent burning example would be fake invoicing.
There's one case, Prem Sundar Chaudhary, that you have just represented.
See, there I referred to a Supreme Court judgment and which referred to a circular issued by the board also. There the lordships of the Supreme Court held that personal liberties are above all. See, we value our liberty. A personal liberty is very important. And therefore, once all the documents are on record, see what are the principles of bail. that the person will not abscond. He will not tamper the evidence.
Right.
Nothing more.
No.
So let the proceeding go on. But of course, there is this is a disputed issue and not as clear as it looks. It's not clear like crystal.
Right.
So therefore, fraud cases one has to be vigilant. See, what you are doing in turn, that in a running wheel you are putting a fork.
True.
Right?
True.
That is not the
So
intention.
in tax matters, what I understand is there are 2 points that are at stake. Number 1 point is collection of revenue, like we are a welfare state, and that money for which the entire case has started, that is the collection of revenue, collection of money from the person who is in question. And the second is that if that person has defrauded the state, if a penalty is imposed upon him, if he is put behind the bars, that sets a deterrence to the society that, look, if you commit anything like this, then you will be put behind bars. So both these points are equally important. Recovery of the money which is owed to the state is as important as setting the right deterrent in the society that, look, if you'll do something like this, then you'll be put behind bars. But how does one balance? Because if you put somebody behind bars, he does not give money to the state, and maybe his family and everyone is enjoying with that money, and he is equally happy that, okay, I'll be behind the bars, and the state is at loss in that case.
See, the main purpose of an exemplary punishment, I would say, I use the word exemplary punishment, is others who see that will not follow suit, will not do the same thing. That is why hanging used to be there, that you look, the person is hanged.
Right.
And if you do the same thing, you will be hanged.
Right.
So that is a way of a deterrence. But I can tell you, in tax legislation, only deterrence by way of prosecution alone will not help. In my view, the state which has collected the money genuinely from the taxpayers, it is public money, and somebody has defrauded it. So therefore, the money lost to the state must be restored to the state. Only putting them behind bars will not, in my humble opinion, serve the purpose. Yes.
So in such cases, under the Constitution, Article 22 says that double jeopardy, for the same offense you cannot punish someone twice. But in tax matters, for a lot of provisions, there are both civil liability as well as criminal liability.
Yes.
And I believe in a lot of Supreme Court cases, that's a decided law that is permissible, because apparently the term prosecution, civil liability does not fall under the term prosecution. So that is permissible. But what comes first? Whether recovery of the money comes first, and then how does it work in practice?
So far as recovery of money is concerned, that has to be done under a process of law, like by attachment of the bank accounts or the attachment of the property that is amassed by using that money. So that is how that money is restored. But it's quite a long legal process. And in recent times, it has happened that many of the people have been subjected to recovery. The state has sold their properties or recovered it or taken possession of that. But then those are much less in comparison, because tax disputes or whatever disputes, they go on for long time. See, there is a first appeal, there is a second appeal, there is a High Court, and then to Supreme Court eventually. And matters in higher courts especially take long time. You have to wait in the queue.
Okay.
So those matters are there, and if at all some stay is obtained in favor, then those state is deprived of its own money,
Right.
which has been defrauded.
So these two proceedings goes parallelly.
See, the tax legislation uses both, the word both, penalty or fine or prosecution, they say all, both. So therefore, either you can be put to a deterrent penalty, which may range from 100 to 300%, or you may be prosecuted for a term that is specified in this section.
But I believe the bar has been raised on which criminal prosecution would start. I believe under GST it is above 5 crores.
Yes.
Under income tax, such bar wasn't
No such
there.
bar
No
is there.
such bar. I was speaking with Dr. Kane Singh last time, and I asked him question that since he's representing Union of India, what kind of cases that you often see in the court, and he told that lately GST matters have been flooded in the court. So what are your views, that what kind of disputes are currently more in nature in Bihar?
See, there are, in my view, many routine matters that are coming to the High Court. And that come to the High Court only because the GST tribunal, which was to be constituted in the Act of 2017, has not still been constituted in the year 2015. 25. I stand corrected, 2025. 25. So 8 years have passed. And we don't see the tribunal, now members are getting appointed. We have to see when the tribunal sees the light of the day. But then I am afraid when this tribunal starts functioning, it will be flooded with several litigations. For the reason the tribunal was not available, everybody was approaching the High Court. And the High Court has been hearing. But mostly on the point of hearing again, whether a hearing has been done or whether some statutory provision has been violated. Very few cases have come where it has come to interpretation.
Under GST.
Yes.
So after GST, what do you think state litigation which were there in the erstwhile VAT and Sales Act, has it been reduced or increased after the implementation of GST?
See, so far as the state earlier act was concerned, that was functional only prior to 17 July up to June. So those legislations, those assessments are already over. In many of the cases, I think the first appeal is also over. The matter are pending before the tribunal. And the tribunal are also slowly hearing the matter.
How many cases do you think gets resolved on the level of first appeal? Or it's a routine thing that it will certainly come for second appeal?
In state tax law, I think the majority of the cases are lost in the first appeal. And they travel to the tribunal.
Most of the cases.
Yes. And in the tribunal, there is a long line. The pace of disposal is too slow.
We have spoken about use of technology, that we have discussed that on the central side, there are more use of technology than on the state side. Okay. In the High Court, what I see is that tax matters require certain expertise and knowledge of, it is more interpretive than other laws we have just discussed. But in the High Court, I see that the cases, the tax matters, when the roster is decided, it is not decided on the basis of the expertise, at least in the Patna High Court, with what I have seen. You practice in other high courts as well. So do you see that it's the same practice where tax matters are assigned to any benches, or in other high courts it is delegated it in a way which a respective judge who is there has some tax background, some tax knowledge?
See, the moment one is elevated to the chair of the judge, it is understood that he would balance and try to understand the matter, and he knows the matter. I have seen many honorable judges who had never practiced in tax. They were either from a criminal background, they had practiced criminal law, they are at the helm of it, and there were some persons from the civil side. But I can tell you, they delivered bigger and better judgments than many tax lawyers had they been judges. I have witnessed those things in my personal practice also. But then these days, as I find that in some of the high courts like Bombay, Delhi and Karnataka, there are judges who are there from the tax background itself. Many of them were chartered accountants also. So there, definitely there is a distinct advantage to a tax lawyer arguing on a issue of interpretation or taxability or otherwise. But I don't think that that is a necessary impediment in the judgment, because judgment requires a rational view and overall view and what the law should be.
Right. I believe it could at most help in understanding the issue in a more easier way.
There is nothing about easy attached to any legislation, be that as whether it's civil, criminal or tax. One has to look at it. That is why it said Lord Denning, no, that one has to look fairly at the language used.
Right. You practice at different high courts across India, but your parent high court is Patna High Court.
Yes.
How is that seen? I mean, at least what I have seen at Patna High Court, that a lawyer who comes from outside, say Delhi or Mumbai, to appear before the court, there's again it's a perception thing, not backed by any evidence or data. It's a perception thing that when somebody is coming from outside to appear before Patna High Court, that person must have some merit, or at least it is appreciated. But how does it happen when you go from your parent high court to appear before? Is it a matter of pride? How does one parent high court sees that?
In my humble opinion, it's not the lawyer's face that should be seen in a judgment. Of course, something is attached when some lawyer from outside comes. Then definitely some would not see his face very often. So one would tend to ask, from where are you?
Right.
But that doesn't materially alter the scene. See, of course, I have seen persons coming from outside. They are also persons of eminence and they have put in enough hard work. And that is why they are invited to the other high courts. Like if I have gone to another high court, then somebody has thought me for inviting them there.
Right.
So you must be known by your work and not by your face.
But how is it seen? How is it perceived? Like, I mean, is it a matter of pride that somebody from our high court is appearing on or dealing with a larger issue which has a larger stake in the forum which only deals with such matters? So is it appreciated at the parent high court level is what I was trying to ask, among your colleagues, among from your seniors, from judges?
See, many of my seniors really appreciated when I went outside. Many of the lawyers in Calcutta or Delhi or Bombay, even Karnataka, appreciated the way I put in things. They come and meet me. I went to Guwahati also. Many lawyers came outside the court after I come out of the court, after argument. And they sought my address and phone numbers and other things. So you see, definitely it makes an impact. If you have placed a thing well before the High Court and the others are watching, see, it is an open court proceeding.
Right.
You are being watched for your performance.
True.
What is the outcome of the court is another matter altogether. That has nothing to do with a personal, thing of an advocate or anybody appearing for that matter. But I can tell you, if you fare well, whether inside or outside, you are appreciated. And I don't think that the court should attach much importance to the face of the person from where he has come. But then they definitely must look into the knowledge and expertise of the person who has come to place the matter before them.
I was just wondering, when you were just speaking about this, that what really shapes an individual? Is it a culture of a place, like culture of the parent high court where you come from, or the issues that you have taken yourself? What really shapes an individual?
See, definitely the parent high court has a big role to play in shaping you up. Like I remember when I was a junior counsel, I would find judges would really communicating so well with the young lawyer and making him at ease. So he was very comfortable. He never felt he was in a high court. So the communication bondage between the judge and the young lawyer was such that shaped his destiny in the long run.
Right. So that
So it has a big role, definitely.
Culture of one court that you have frequently appear.
Yes. Yes.
Okay, great. Some of the cases that you have been part of, I wanted to discuss and learn out from them. One case, again, we were talking about implementation of technology, and with artificial intelligence and internet and everything is going online. But there's this one case that I have read in which you were part of. That case made me wonder, and I would like to I would like you to tell more about that case, where the GST Home Traders versus Union of India, where the GST filings are done online. The option to do everything is online. It's a great option. Everybody wants things online. But reading this case made me think that what are actually the limitations of technology once you are logged? Like what happened in this case, that once you are doing the filing, correct me if I'm wrong.
No, absolutely.
Once you are doing the filing, CGST and SGST and IGST has to be separately filed. But what this person did was he filed the entire amount at IGST, because of which there was a mismatch between GSTR 3.1 and GSTR 3B. And he submitted it, and he later realized after submitting that what a big mistake that he has done. And because of this mismatch, it was showing on his tab that he still needs to submit an amount which runs through some 3 crores or something. And he had to bring this before the department, and department did not pay any heed to this, because again, limitation of technology. And that is where High Court has to come into the picture and give relief. So was this limitation of technology with more implementation of everything going online, such disputes will keep on coming?
It is not only technology. So if you have come across the words miss the bus, that's a common phraseology, miss the bus. Whether you can run to catch it, how do you run to catch it?
Right.
In a legislation, in a tax legislation, you can catch it only if a way and mean of catching it is provided.
Right.
See, like you said, technology that was for making the compliance easy. Earlier times, what happened? That we would fill up the return manually, go to the counter, stand in the queue, file the return.
Right.
With the advent of technology, what has happened? Everything has become online. Sitting at home,
you can do it yourself.
You can sitting in a boat in a vacation, you can file your returns. You can make a statutory compliance. It is not about technology. The case which you discussed was argued by me in the High Court. See, what happened in that case was that the person had made interstate purchases. And on making interstate purchases, you pay IGST. Right? But under the statutory provisions and circulars, they are to be adjusted with the CGST and SGST in equal proportions. That is how the legislation permits. You can do that.
Right.
What that assessee did was he put in the purchase head itself in the sales head. So the percentage of profit, purchase and sale are definitely bound to vary.
Right.
So there is a difference of profit percentage between the purchase and sale that got suppressed, number one. In the purchase, it was all an interstate purchase. So everything was reflected in the IGST column. He filled it, and then there is a button submit, he pressed the button.
Mm.
The moment you press that button,
Mm.
it is under a submitted option.
Mm.
You cannot come back.
Mm.
There he realized, maybe a second later,
Mm.
that he had done a mistake. He stopped there. But the GST did not.
Mm.
He started writing, corresponding with the authorities.
Online, he had no
commissioner.
recourse to correct it.
That is why I was driving my point home. He could have rectified his return had there been
An option.
statutory provision enabling such rectification.
Correct, correct.
Though the rectification provisions are there in the Act, but they are far too limited.
Okay.
Omissions of this nature cannot be cured. Under the income tax law, you can file a revised return until 1 year. The time is given. Here, there is no option.
And why is it so? I mean,
There is no statutory provision. The makers of the law did not think of a provision of revision. They didn't bring in it. See, the matter was first considered by the Bombay High Court. The Honorable Bombay High Court say that the central legislation must think of it, incorporating that provision. And they made such directions. When the matter went to Supreme Court, the Supreme Court also agreed with it. Yes. And they made Central Board of Indirect Taxes a party, and they expected that certain amendments are brought in to facilitate revision of return. While arguing the case before the High Court, I explained the High Court the facts and said, Lords, I am unable to rectify my return, but the fact remains that I have paid my tax and it was only in the name of IGST, but that was to be adjusted under a statutory provision itself. So it is deemed payment of tax. The state is not put in a loss at all.
Right.
So the High Court held, then where there was no loss of money to the state exchequer, there was no harm giving an opportunity to the assessee to file a rectified return, if not permitted online, manually.
Right.
And that is how the judgment came. I think in the Patna High Court, that is the first case of its kind. And that has shown the light of the day. I think the government would look into the judgment, both of the Honorable Bombay High Court and the Honorable Supreme Court, and then the Patna High Court. I think other high courts again, after these judgments, have followed suit.
Such option should be there, because such clerical mistake could happen with anybody.
Yes. You do not tax for a clerical error. You tax for a transaction of sale.
Right. But the department was asking him to pay again.
Again, yes. Department was asking them to pay again and seek a refund.
The refund, yeah.
But then I had pointed out to the High Court that even under the refund provision, such refunds were not permitted.
Okay, is it?
So had I paid that money, perhaps later on the department would have said that there is no such statutory provision. So the High Court judgment came as a big sucker and has explained the GST law in that context.
Right, and that this amount is also huge, 3 crores for a small...
See, 3 crores or 300 crores doesn't matter to a judge or to a law.
No, but to...
What is important is as to whether the amount is payable and whether the state has actually received it or has lost it. Had it been lost to the state, then there was no question.
Right.
But it was not a case of loss at all. How could a loss be contemplated?
Right.
The money was already paid at the time of purchase.
Right. Now, had there been provisions for refund, still for a medium and small size enterprise, such amount, it's a lot of money to be paid extra to the department and get at a later point of time such refund.
Paying such money is one thing. The issue is whether after payment you can secure a refund.
Right.
Because now the GST provision, there is a limited scope for refund. There are preconditions to be satisfied. And you must fall in the category of refund. And in my humble view, the case at hand did not satisfy the requirement of a refund provision. So refund would have been denied.
Right. But this case has come before the High Court after a really long time. So I assume this individual must have tried every other means to...
He approached till the Central Board of Indirect Taxes by way of a representation. But unfortunately, the Central Board of Indirect Tax only sought opinion and discussed with the local tax department and did not even hear the assessee. That was also a big grievance, that I was never heard. I made a representation, but I was not heard. And they decided unilaterally.
So in cases like these, do you have any advice for small and medium-sized enterprises that when faced with such issues, should they approach High Court straight away rather than chasing departments again and again?
See, GST is a new law. Even I do not say it is 8-year-old. 8 year is nothing in a legislation,
True.
be it of tax or be it civil. So life is not complete now. What I say that the law being technical and requires compliance online, the taxpayer must be educated. The department has been carrying out such program, but then I think that is not enough. And there are better ways and means of educating the public at large. See, big corporate clients, they engage chartered accountants, lawyers to advise them. But for a small businessman, incurring such expenditure for expertise is often difficult. So as you said, the law must be made more simple. Even the compliance must be made more simple and transparent. Both should know, both the officer should know what the taxpayer is doing and the taxpayer should know what the officer is doing. Because I can tell you, I am reminded of one judgment of Steel Authority where Justice Arijit Pasayat, speaking for the bench in the Supreme Court, just said that one has a right to know what went wrong. So unless you know what went wrong, how can you explain it?
True. And there's so much at this point of time where there's no clarity even to the department, because the jurisprudence is being shaped with each passing.
Yes. Clarity will happen in time.
Clarity will happen in time. And such disputes play a role in bringing...
That is how where the lawyers are required.
True. There's one more case that I wanted to discuss with you, Mapara Laboratories, where the dispute was in regards with sale on MRP. And I believe this case was instrumental in changing the statute.
Yes.
Can you please tell us about...
See, I will tell you very briefly.
Yes.
Because the sales tax law provided for tax on maximum retail price. That is called MRP. Under the sales tax legislation, the tax is what? On sale.
The sale.
And on sale price. So what the language of sale price will be an amount which is actually received by the seller. Maximum retail price is the maximum price at which the seller can sell.
Right.
Assuming the rate of MRP, maximum retail price, in a given commodity is 100 rupees. But then the seller sells it, say, for 80 rupees after giving discount. So the question arose or would arise is as to whether the tax will be on actual or on the maximum. That was the question before the High Court. So High Court held that it was not permissible to levy tax on MRP. Rather, it has to be on the actual realized value.
But the statute said that
that is how, yes, that statute said so. That was an anomaly, which the High Court, by declaring the statute ultra vires struck down the provision and the law got amended.
So this case was under which subject? Was it under validity of law or
It was under the validity.
Validity of
Yes.
Because this was under question.
Yes.
Okay. Do you face on the tax side a lawyer practicing at the tax side and a lawyer practicing, let's just say, on the criminal side? Is there a difference of any ethical dilemmas?
See, ethics plays a big role in shaping up an individual. And it's not only in tax. It is in civil side or a criminal side also. It is only about temptation, what lures you. And in many cases, it's money. The moment it is a vice attached to a profession or any work, then you work for, again, an exaction.
Right.
So there, I think it is like a corrosion in values. And there the ethical issue will come. In my humble view, a professional practicing on any side, or be it a human being, any human being, they must be rational, prudent, and work with circumspection, honestly.
True, but the system that we have, even the gravest offender requires representation in the court. And someone who is representing on the criminal side, despite knowing that, let's just say, what's the gravest offense that we could think of? A murderer or a terrorist. So it's an individual's job to represent this individual, despite of knowing that, okay, he has committed this, because the system, not just on his commission, the punishment and everything is decided through trial. And that is in regards to a criminal case. Similarly, in the tax matters, going through the file, you would know that, okay, this individual who has come before you has evaded a tax. So do you face such ethical dilemmas that I should not, or maybe...
I think ethics should not be attached to this line of thought. For the reason I tell you, that a lawyer is not a judge.
Right.
A client on the petitioner side, naturally he will be represented by the person aggrieved. And in case of a tax offender or a criminal, it will be represented by the lawyer of that side. So he has come to him for a purpose, to save him. The lawyer's work is not to judge him at that stage. If that were so, then perhaps no criminal would be, or no tax offender would be defended by a counsel in a court of law. It's no discretion of a lawyer to start judging before a judge judges it.
That I understood, but on an individual level, I'm taking my example here, that let's just say there are two people, one who has committed murder and has come before me for representation, and one who has evaded, let's just say, tax. I'll always be more comfortable representing this individual who has evaded tax than this individual who has murdered someone. So
One
there
has
are
not to be so selective.
Yeah, but there are difference of moral compass. An individual has different kinds of moral compass. So I believe someone who is practicing at the criminal side has to have a very strong or loose moral compass. I don't know.
Morality has a different definition. That is what I would say.
Yeah, true. Anyways, moving on. What do you think? In a tax matter, representing taxpayer on the petitioner side and a lawyer representing the department, what are different things at stakes for these two different people? How are different incentives for these two different people?
With my own experience, I can tell you, it is not the lucrative part of the thing that has to be seen first. Like petitioner counsel is paid more and the state counsel is paid less. Now there are times where even the state counsels are paid more than the petitioner.
Okay, is it?
Like in prohibition cases, top-end lawyers from Supreme Court were representing the state itself. And they were paid fee enormous to the tune of 70 to 80 lakh rupees per day per parents. The state was bearing the cost. So it all depends. But normally, the fee of a state counsel is less. But that by itself is no yardstick to determine their quality of renderance of judicial work. So I would say that there is no such equation. One should not equate the petitioner counsel. Everybody has a separate role to play. The petitioner counsel is to defend the client, whereas it is their job to defend the state. And it is a matter, profession is a matter, you see, of individual choice. You have chosen to become a petitioner counsel, you are successful there. Or if you are chosen to become a state counsel, you are happy there. These are the only things.
Okay, the incentive, like you just said, the financial incentive for a petitioner could be more, but what is again more is that your reputation is at stake, that if you lose this one case, you have got more to lose than somebody who is representing the state. Is it not?
Normally, it is understood that the state counsel has nothing to lose. Because he has nothing to lose for the reason that he has allotted brief from the state. And he will be appearing in the state. Either he or some of his colleague or somebody. But for a petitioner counsel, he is being viewed from outside. Also. Not apart from inside. The performance of a counsel is being watched by a judge, by the advocates who are in the courtroom, and by the public. Nowadays, it is a video conferencing, you may be watched anywhere. So, in that situation, a success of a petitioner counsel definitely helps him in getting some other cases. But that does not stop there. Many big cases are, good cases are lost, and many lost cases are won. It depends on the articulation of the counsel and the judge, the manner in which it delivers the judgment. So, there is nothing attached to it in that sense, as you said that.
How are state counsels incentivized for winning more cases for state?
See, they are promoted. They will become standing counsels, they will become additional advocate generals, they will become advocate generals. That is their remuneration.
State has its own hierarchy.
Yes, state has its hierarchy. And they are selected in a selection process also. That is one of their important criteria.
So the incentives are different. It's not comparable.
Yes, it's not comparable. Yes.
Since you practice at the tax side, you must also be aware of the economy of the state, that how is Bihar prospering over the years. Can you give us some insights?
Like me, you are also a resident of Bihar. But I am also born and brought up in Bihar.
Certainly you'll have more insight. Like this one time I remember in the court, I believe Justice Karol only asked that how much should be the turnover of this company that you are representing. And you said, my lord, it runs to 500 crores. And he was so surprised to hear that Bihar had such company. So that is the perception, at least.
I can say you have a razor-sharp memory, razor-sharp intellect, and a photo memory.
Thank you.
That you remember.
I was there in the court, so I remember.
You remember. I think that was way back
21. Yes.
And this is 25. Still, you remember that. See, of course, we have persons with good turnovers in the state also. That is why the state has got good tax collections. There are many corporates who have their huge turnover in the state of Bihar. And they are paying taxes in that proportion. And that is how the coffers of the states are enriched.
So over the years, I believe the ecosystem and everything in the state has become better, which has enabled such corporates.
Gradually it is improving. Yes, I see some light.
How much the simplification of law and the institutional ecosystem has helped in enabling so, in your opinion?
What do you mean by ecosystem here?
Good policies, better dispute resolution, better laws, all of that.
See, it is not only better laws and better policies, it is a better implementation that matters.
Yes, implementation
So the
included, yes.
purpose has to be good. Like we had an industrial policy,
Right.
then we had certain conditions. But then the manner in which the interpretation took place, that many things of under the incentive policy of the state reached up to the Supreme Court.
Yes. We have heard
So
about
the
such
meaning
cases.
of that incentive is lost.
Right.
In fact, the person for whose benefit the law was really made, like you said, good policy, that got lost in oblivion.
Right. I've heard about such cases earlier that
Yes,
there are a
many.
lot of cases wherein, despite Supreme Court's order, state has not honored such cases. And
There are many such examples, and I tell you that many times, by the time the judgments are rendered, the legislations are gone. So ultimately the relief is denied. And I think that is one great reason for non-industrialization in the state. That we don't have a good industrial atmosphere. But now the state government is making good effort
right.
to bring in more and more entrepreneurs in the state.
Right.
We hope so.
Right. Gradually, it's becoming better.
Yes.
Okay. My second last question would be that what would be your recommendation for someone who is contemplating to start practice in state of Bihar on the tax side?
See, it is an individual's choice. But the moment one decides to come in profession, I have only one suggestion. I can't give a sermon. That work hard.
Right.
And there is something in store for you, and that all depends on your performance. The better you perform, I hope you have a better future.
Great. The last question in our podcast comes from our previous guest. So the previous guest was Dr. Kane Singh here, and he has a question. He did not know that it was going to be you. It's a general question. We have a format here. We'll take a question from you as well.
Yes.
So this question is that interest of the client and profession ethics. If there's a clash of interest, which one would you choose?
See, here
and
also...
This question is more relevant for you because you represent on
here
the petitioner
also,
side.
I think you are understanding or comprehending ethics with something to do with corruption. See, so far as I individually is concerned, I am of the view what I have advocated is for a professional never to indulge in any activity that is unethical. I have abhorred giving and taking bribe. You don't buy judgments by bribing. That would never stand the test of law ultimately. And I tell you that what is the greatest of the court is the court of conscience.
True.
And I vividly remember Mahatma Gandhi telling it. And in the Jharkhand High Court, that there is one emblem of this also. That is a bigger court above this court. That is the court of conscience. You have to be conscientious.
Very beautiful put. Great. Thank you for your time. This has been an enlightening experience talking to you.
Thank you very much for the invitation.
I am Sachin Raj, and you are watching People Policy Precedent. If you have derived any value out of this episode, please consider supporting us by sharing with your friends and subscribing to this channel. Thank you.